The last one we'll talk about today is the Corporate Transparency Act. This is the one that is not a state law. This is a federal law. Short version, Corporate Transparency Act was passed a few years back, and it is run out of the Treasury Department of the federal government. The intent of this law was to prohibit money laundering for terrorism, for drugs, sex trafficking, things of that nature, bad stuff. Because in the United States, it's really easy to make a corporation, and then that corporation can be owned by another corporation, and you can have this whole Russian nesting doll situation, and it becomes very difficult very quickly to track where money is flowing to and from. So what the federal government decided is we're going to create this requirement that most corporations have to register some amount of information with us. And we'll talk about what you have to register in a moment. This is kind of tipping my hat a little bit to my biases again, but this wasn't a particularly well thought out law as it applies to our industry. A third of the people in the United States live in HOAs. There are hundreds of thousands, if not millions, of HOAs around the country, all of which, most of which, are nonprofit corporations. As such, they are required to comply with this Corporate Transparency Act. There are much better ways to launder money than through an HOA. I've been told. Having the association be required to comply with this creates a whole set of hurdles. I will tell you that this is something that everybody from a local to a national level is working to get HOAs exempt from. In fact, just last week, CAI, Community Association Institute, which is a nationwide organization that advocates for and helps homeowners associations. There's a Minnesota chapter here as well. They had their legal team file a lawsuit to enjoin, which is to say stop, this from applying to HOAs. I've got it printed out in my backpack. I haven't had a chance to read it yet because it's about 60 pages long and got a lot to do. We'll see if that works. I don't think it will. I think in the next, we'll say 5 years, the Corporate Transparency Act will stop applying to HOAs. But as it sits now, my guess is it's going to apply when the deadline comes, which is what we'll talk about now, which is going to be January 1st of 2025. So on January 21st, 2025, so just a few months from now, every corporation, with some exceptions that's not going to apply to your HOAs, needs to register with the federal government all beneficial owners. Now, this place that you register is a website called FinCEN, F-I-N-C-E-N. It's free to do personally if you'd like. You're required to do it by January 1st for all beneficial owners. And importantly, this database of HOA board members, and frankly every corporation owner, is not publicly available. It is only for the Treasury Department. Can't guarantee China or Russia won't hack it, but it is for now only the federal government and the Treasury Department who has access to it. Every corporation is required to register the name, address, date of birth, and a copy of the driver's license or passport for every beneficial owner. Beneficial owner is defined in the statute as either someone who owns, is it 25? Yeah, 25% or more of the corporation. That's not going to apply to most HOAs because if there's 100 units and I own one, I own 1% of the HOA. If it's a 4-unit HOA and everybody has equal shares, then I own 25% and I'm a beneficial owner. But where it's going to apply to all HOAs is that it does require anyone who exercises substantial control, it defines them as a beneficial owner. In practice, that means board members. Every person who serves on the board probably does exercise substantial control over the association and therefore will need to register. This, of course, creates a whole slew of issues. Well, what happens if we don't register? Willful noncompliance contains a whole slew of punishments, including up to a $500 per day fine. We'll see if there is going to be some sort of administrative arm that helps enforce this. I can't imagine they're going to be coming and gunning after HOA boards who don't register, but stranger things have happened. The management company always, and for HOAs, does what the board asks it to do. The management company doesn't make any decisions. The management company doesn't say, we're going to fix this, we're going to do this, we're going to hire this vendor. The board ultimately gets all those decisions. So the management company might help facilitate this in terms of say, hey, we've got a process set up where we can do the Corporate Transparency Act reporting for you for a fee. But at the end of the day, the management company is not going to be considered a beneficial owner because they don't exercise control over the ultimate decision-making of the community. I don't remember the exact language, but basically we looked at it and said, okay, potentially you could make the argument that only one person needs to register. Again, I'm very risk averse. So my advice to all my association clients is we need to have every board member register. You've got to do this. If only one wants to do it, something about leading a horse to water and making them drink, but nothing I can do to force them. I'm just providing advice. The association address is probably going to be whatever your registered address is with the Minnesota Secretary of State. If you have a management company, more likely than not, it's going to be the management company. I've talked to management companies that are going to say, we're going to charge a fee and we're going to do it. There are third parties that do it. We've got a process and procedure in our office set up where we do that for associations that ask us for what I think is a very low yearly fee. It's $250. It's kind of choose your own adventure. What works for you? I'm always hesitant to have the board actually do it because they might forget. All of a sudden the entire board turns over and they don't have that